Hi, myself Dr. M. Saranya, Assistant Professor of PBA Department. Now I am going to present a topic on essentials of valid contract under Indian Contract Act 1872. A contract as defined under Section 2 H of Indian Contract Act 1872 is an agreement enforceable by law. For any contract to be valid under Indian law, certain essential elements must be present. The contract may be void or unenforceable if any of these elements are missing or defective. These essentials form the foundation for the creations of binding obligations between parties. Below are the key essentials of a valid contract. First one is offer and acceptance. A contract is formed when one party accepts a valid offer and the other party accept the better offer. Accept the offer. The offer should be clear and communicated properly to the other party. Acceptance must be unequivocal and correspond exactly to the terms of the offer. An offer can be revoked any time before acceptance unless it is made irrevocable by a provision like an option contract. Next one is intention to create legal relation. For an agreement to become a contract, there must be an intention to create legal relations in domestic and social agreement. The intention is generally not to create enforceable and legal obligations. For example, an agreement between family members for a casual meal would not typically be considered a contract. In contract, commercial agreements are presumed to have the intention to create legal relations, making them enforceable in a court of law. Next one is lawful consideration. Section 2 the of Indian Contract Act stipulate that a valid contract must be supported by lawful consideration. Consideration referred to something of value that is exchanged between the parties to the contract. It can be either in the form of money, goods, services, or promises. However, the consideration must be lawful and not illegal, immoral, and against public policy. A promise to do something that is prohibited by law, such as selling illegal drugs, cannot form a valid contract. Next one is capacity to contract. The parties entering into a contract must have the legal capacity to do so. According to Section 11 of the Indian Contract Act, the following person are competent to contract. First one is a person who is of the age of majority 18 years or older, a person of sound mind, a person not disqualified by law, such as a person educated as insolvent. If either the parties lacks the capacity to contract, the agreement is voidable at their discretion and in some cases void. Next one is free and informed consent. Consent of the parties involved must be free and not obtained through coercion, undue influence, fraud, misrepresentation, or mistake. If consent is obtained through any of these means, the contract becomes voidable at the options of affected party. The Indian Contract Act ensures that both parties enter the agreement voluntarily and with a clear understanding of the terms. Next one is lawful object. The object of the contract must be lawful and against public policy. If the subject matter of the contract is illegal, such as an agreement to commit a crime, it's void. For example, a contract to smuggle goods is not enforceable as it violates legal and moral standard. Next one is certainty of terms. The terms of the contract must be certain, definite, and clear. If the terms are vague or ambiguous, the contract may fail. For instance, an agreement to sell goods without specifying the price or quantity would not form a valid contract because of the terms of uncertain. Next one is not a void agreement. Finally, the agreement should not be void or voidable. A void agreement is one that it's not enforceable by law from the outset. While a voidable agreement is one where one party has the right to enforce or assign the agreement due to issue like misrepresentation or undue influence. Thank you.